And welcome to today's episode of Love the Life You Live. This is John Hilton, your host, and today I'm going to be talking to you about estate planning and the 3 critical documents you must have to have a complete foundational estate plan. You must have a properly crafted financial durable power of attorney. You must have correctly completed advanced healthcare directives, and you must have either a will or a trust. And in today's episode, I am going to be explaining to you why a trust is probably better for you, and why having these documents created correctly is so important. Why it is so important that you do not trust these documents to an online will processing center or to that cheap lawyer down the street. I conducted this training a few weeks ago in a webinar, and for today's episode, I've borrowed some of the portions of that 90-minute training to share with you today. So the third most important decision you should make to protect your family is to plan for your financial incapacity. Now, Bill was an 84-year-old multimillionaire, and I knew Bill, I met Bill, and this is his story. Bill made his fortune trading on the stock market. One day, he met a 25-year-old video store clerk and started teaching him how to make money trading stocks. After a few months, Bill gave this video store clerk $14,000 and challenged him to invest and turn it into much more money. Now, Bill's daughters learned about this $14,000 gift and immediately decided Bill had lost all judgment and capacity to make decisions about his money. They petitioned the court for emergency guardianship and conservatorship. Now, in Arizona, guardianship refers to control over the person, and conservatorship refers to control over their financial affairs. After months of hearings, the court granted their petition and appointed one of Bill's daughters as his guardian and conservator. Bill lost all of his rights to drive, to vote, to determine where he would live, to determine who his friends could be. He also lost all of his right to control any of his money. Now, during the final hearing, after the judge made his determination, Bill pleaded with the judge to appoint anyone other than his daughter. He explained to the judge that his daughter was a mean and ugly person who had been trying to get control of his money for years. The judge would not be dissuaded. Bill appealed to the Arizona Court of Appeals and ultimately to the Arizona Supreme Court, and still could not get that ruling changed. Bill's life, as he had once known it, was over. Now, what could Bill have done differently? Well, Bill could have created a power of attorney in which he named his personal choice for who would control his assets when he was no longer able. And even if the court decided he needed a guardian, the guardian would not have gained access to his fortune. Or even better, Bill could have transferred all of his assets to a trust and named a successor trustee to manage his financial affairs for him when he became incapacitated. But what about what happens to you if you become incapacitated? Recently, and this was, I believe, I don't remember what state this happened in, but it was just in the past few months. A young couple got engaged and were happily planning their wedding. Then the groom became ill and was hospitalized with COVID-19. Within a day, he was in the ICU on a ventilator. His fiancée tried desperately to get the hospital staff to tell her what was going on, but because she wasn't a blood relative, they refused to tell her anything. And obviously, he was not able to give permission for the healthcare staff to speak with her because he was in a coma and intubated. And because it was COVID-19, she was not allowed to even enter the hospital or try to visit him. A couple of days after the love of her life was admitted to the hospital, someone in the ICU finally told her that her fiance had been moved to a different floor. She was so excited, she was thrilled, believing that he must have gotten better and didn't need an ICU care any longer. After calling around all day, she finally found him, only he hadn't gotten better. He had been moved to the morgue. He had died. So what could this couple have done differently to avoid this heartbreaking end to their happy romance? What one decision could they have made that would have allowed her to speak with the hospital staff and keep abreast of his progress? This is it. They could have created a healthcare power of attorney and a living will, naming each other as each other's power of attorney, or at the very least, as an approved person. So now let's talk about Terri Schiavo. Many of you may remember Terri Schiavo's story. This was back in the 80s. Terri Schiavo, the current belief is that she had an eating disorder, which caused her to ultimately have a heart attack and experience prolonged lack of oxygen to her brain and cause brain damage. And Terri's husband felt like the best thing for Terri was to take her off of life support. Terri's parents were adamantly opposed to that, and they insisted that she be kept on life support indefinitely. So the big question became, who had the legal right to decide Terri's disposition, her husband or her parents? And those of you who are old enough to remember this story, you may remember that this transpired over many years. I believe it was like some 5 odd years. And it literally split the country in half over who was right. Was it right to take her off of life support? Was it right to keep her on life support indefinitely? Did the husband have the right to make the decision, or did the parents have the right? And, you know, there were 3 different parts of this argument that went to the United States Supreme Court, because we had no law to make this decision for us. And ultimately, Terri's husband prevailed, and the court sided with him, and he made the decision to take Terri off of life support. Now, these terrible events could have been avoided if Terri had properly executed a simple document. Now, many of you have executed such a document, but I can guarantee that for many of you, it is out of date and won't work when you need it. And it's unlikely to be comprehensive enough to provide enough detailed guidance on how you want to be cared for in the event you do become incapacitated. One additional point related to planning for your possible future incapacity. Will you, or maybe your aging parent, need long-term care? In Arizona, the average cost of long-term care is about $90,000 a year, and that's the average cost. Many long-term care facilities are less expensive, but you guys know what that means. It's probably someplace you don't want your parent to live out the rest of their life. Other long-term care facilities are much more expensive, and those are the ones where you probably would not care as much if your parent had to go into a nursing home, had to go into long-term care to be in one of those nicer facilities. But looking at this $90,000 per year, simple math, if you or your parent have, let's say, $250,000 in an IRA, you will not qualify for the Arizona long-term care system, All-Tex, which is Arizona Medicaid. You will not qualify for All-Tex assistance. And within 2.5 years, you will have exhausted your entire life savings just paying for long-term care. Now, the good news is that we can help you plan to keep your hard-earned money while still qualifying for state assistance to pay for your long-term care.
You know, none of us wants to think about our parents ever having to be in a long-term care community. But the truth is, no long-term care resident is ever there by choice. Typically, a parent will find themselves in long-term care due to an accident or illness that incapacitates them, requiring round-the-clock nursing care that we, as their children, are neither capable of nor trained to deliver. Obviously, long-term care is not what we want for our parents. But what if the worst should happen? Did you know that in Arizona, the average cost of nursing home care is almost $100,000 per year, and Medicare does not cover the cost of long-term care? So without proper planning, your parents could lose their home and entire life savings paying for long-term care. In my upcoming webinar, 5 easy steps to prepare your parents for long-term care while protecting their assets, I will show you how to help your parents plan for the possibility of long-term care and legally protect their assets from the government in the process. Simply go to www.terrabellalaw.com/LTC to register for the next scheduled webinar. That's terrabellalaw.com/LTC. Or call our office at 520-428-1188 and tell them you heard about this invaluable webinar on the radio.
Did you know that an online will could leave your family in court in conflict with one another? Hi, this is John Hilton, Principal Attorney at the Terrabella Law Group. I'm the attorney your family calls after you die and they discover your will has left them at the mercy of the court. If you want to learn more, join me for my free online workshop, The 5 Most Important Decisions You Should Make to Protect Your Family Now and Forever. Head on over to www.willsworkshop.com to register for this free workshop or call us at 520-428-1188. You're listening to Love the Life You Live with your host, John Hilton. So let's talk about your estate plan. There are 3 possible scenarios. 1, you have a will. 2, you have a trust. Or 3, you have not done any planning yet. Those are the only 3 options, the only 3 categories that you can fit in. You have a will, you have a trust, or you have done no planning at all. Now, this does not mean that you don't have a plan. Just because you haven't planned doesn't mean you don't have a plan, because the state of Arizona has a plan for you. And if you haven't planned and we have to use Arizona's plan for you, you may not like it, because that plan will distribute your assets to your children. If they're under 18, they'll hold it in a special trust until they turn 18. When they turn 18, they get it outright and free of protection. It will distribute your assets to people in your family that maybe you don't want to receive your assets. And it's going to go through this probate process. Now, assuming you have created a trust or a will, when was the last time you had it reviewed? Because of changes in your circumstances, changes in the law, your estate plan should be reviewed at least every 3 years. Additionally, you should make sure your plan was created with a lawyer who made sure your plan will work when your family needs it most. So I mentioned a while ago that the state has a plan for you. So let's talk about what that is. If you have no estate plan and you become incapacitated or die, the state has an estate plan for you, and it's called going to court. So a judge can appoint someone to make decisions for you, to give your family access to your assets, or to direct where your assets should go. Now, this court process is called guardianship or conservatorship if you're incapacitated. It's called probate if you've died. The court decides where your money goes, and it may not be to whom you would choose or in the amount you would choose. So even if you have a will, your family will go through this exact same probate process. Let me say that again, because this is a big point of confusion when I meet with clients. Even if you have a will, your family will go through the probate process. The only difference is that with a will, you get to decide who will receive your assets when you die. Now, probate is expensive. It requires a lot of energy and attention, and it's time consuming. And a lot of the clients who come to visit me, they come because they've had a family member who has died, and they have been responsible for moving that estate through the probate process. And they've realized that it's not something they want their family to do for them when they die. I ask every one of them, every time, this is just the question I always ask, if you had it to do over again, would you do it again? And every one of them like, no, I never want to have to be a personal representative and push somebody's estate through the probate process again. It's so much work.
Thank you
It's so
for joining me on
exhausting.
Love the
There's
Life
so
You
much
Live.
to do.
This is John Hilton. I invite
Now,
you to join me next
court
week,
is
Saturday at
costly.
11:30
There
a.m.
are attorney's
for
fees
more
and executors'
of the
fees.
thought
There are
leaders, the
appraisers'
business
fees,
people,
court
the
filing
artists,
fees,
the
bond
authors
premiums,
who
and
will
creditors'
bring
claims.
you more
A
meaning
simple
and joy into your
probate
life
in
so that you can
Arizona
truly
today takes a
love the life you
minimum
live.
of 9 to 12 months. And during this time, your creditors are getting paid, but your loved ones may not have access to your assets. Now, who would you rather have access to your assets? Your creditors or your children? Now, the court process is also totally public, meaning anyone can go down to the courthouse and pull your court records to see what you own and who is getting it. For example, on the screen, you can see this is the will of Jackie Onassis. And if you want, I could show you the will of John Lennon, John F. Kennedy Jr., and Babe Ruth. I could show you the will of Jerry Garcia. You could see these because they all went through the court process called probate, and all their records are public. And my point here is that a will is public and it does not avoid probate. When a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money. The only plan that is private, avoids probate, ensures your children receive your assets when you want and how you want, and can save you substantial estate taxes is with a properly funded trust. But we're going to talk about more about that later, but keep that in mind. And finally, and possibly worst of all, if your children are under 18 and something happened to you, they would be entitled to all of your assets outright with no restrictions at age 18. And I talk with a lot of parents of younger children, and they've done the right thing. They have investments, and they often have large insurance policies because they know there are going to be a lot of expenses to raise their children, get them through college, get them established in their careers if they die while their children are young. But can you imagine your 18-year-old suddenly inheriting your life insurance policy? And one last thing. You might want to ensure that your kids receive their inheritance protected from lawsuits against them, that they receive their inheritance protected from future creditors or even a future divorce. Now, most adult children have no idea how to keep an inheritance separate from their community property. And as a result, they'll typically lose half of it to a future ex-spouse during a divorce. However, if you leave the inheritance for your children in a protected trust, your children will be able to keep all of it, even if they get divorced, file bankruptcy, or have a court judgment against them. So there is a better plan, and that plan is called a revocable living trust. Now, when you create a trust, you get to choose how to distribute assets to your heirs. They don't just receive assets at 18, but instead, according to a schedule that you determine. Most trusts distribute assets to their beneficiaries at certain ages or stages. For example, they may get 1/3 of their assets at 25, 1/2 of the remaining assets at 30, and the balance at age 35. Or they may get 1/2 upon graduating from college and the remaining balance upon graduation from a graduate school. This is an acceptable way to plan, but there's an even better way. How many of you would like to own assets that can never be touched by creditors, will never be subject to estate taxes, and can never be taken away in the event of a divorce? Yeah, of course, we'd all like that. But now, what if I said that I could give this all to you, but in exchange, you could not control those assets? You'd probably be a little less interested. Well, in our living trusts, you can give your children assets that can never be touched by creditors, will never be subject to estate tax, and can never be taken away in the event of a divorce, and you can give them complete control. These are cutting-edge techniques that only the most knowledgeable estate planning attorneys are taking advantage of, And I'm betting that most of you would want to include them in your plan. So as I said, the only way to keep your family out of court, either in the event of your death or your incapacity, is to have a fully funded living trust. This means that you've got a trust prepared that is properly and custom drafted for your family to say exactly what you want to happen to your assets in the event of your incapacity or death. And all of your assets are owned in the name of your trust. Now, if you already have a trust, chances are it's not been updated since you created it, and it's likely out of date because your life has changed, or the law has changed, or your assets have changed. I can tell you right now, the Secures Act that came into effect in January of 2020 has caused many trusts that were created prior to 2020 to need to be amended to account for that new law that deals with distribution of your IRAs and retirement accounts. Now, it's also very likely that your assets are not even properly owned in the name of your trust. And, this is something when a client comes to me and says, John, I would like for you to review my trust. I'd like for you to make sure that this trust is valid, that it's going to do what I believe it's going to do. Before I even open the trust and start looking at it, I ask the client one question. And I ask them, what assets have been transferred to the trust? What assets are owned in the name of the trust? And I would say at least 75, 80, maybe even more % of the time, the clients will look at me, get a glazed look in their eye. Sometimes they'll say, what do you mean? Sometimes they'll say, I don't know. Sometimes they'll say, well, I think our house is in the trust, but we're not really sure. Very rarely does the client say, yes, everything has been transferred to the trust. My house is in the trust. My bank accounts are in the trust. I've retitled all these other assets to the trust. If I didn't retitle them to the trust is the beneficiary. I can think of maybe 1 or 2 times that I've gotten that answer from a client. And I mean, that happened just a couple of years ago. I had a client come in. They had spent thousands of dollars on their trust. They were quite proud, and rightly so, that they had made the decision years ago to create this trust to protect their assets, to make sure that their children were able to receive their assets without going through the probate process. And I asked them that question. And they absolutely looked at me like I was speaking another language. And they said no one had ever told them that they needed to transfer assets to their trust. Their attorney did not tell them that their trust would not work if it did not contain all of their assets. And, this is just so common when we have clients who go onto the internet or go buy an estate planning package and do it themselves. Or even worse, when they go see a cheap lawyer, this cheap lawyer down the street, he'll do anything for you. And that lawyer does not properly guide them to make informed and empowered decisions and then keep their plan updated and their assets owned properly throughout the rest of their life. And, you would think that this would be malpractice on the parts of attorneys who create these trusts and don't make sure they're properly funded because they're creating a plan that will absolutely fail when the client needs it. But it turns out it's not malpractice, it's common practice because almost all lawyers do that.
Did you know that an online will could leave your family in court in conflict with one another? Hi, this is John Hilton, Principal Attorney at the Terabella Law Group. I'm the attorney your family calls after you die and they discover your will has left them at the mercy of the court. If you want to learn more, join me for my free online workshop, The 5 Most Important Decisions You Should Make to Protect Your Family Now and Forever. Head on over to www.willsworkshop.com to register for this free workshop or call us at 520-428-1188. You're listening to Love the Life You Live with your host, John Hilton. Hey, if you have questions about any of the material we've talked about today, or if you would like for me to address a specific question that you have on the air, drop me a line. John at lovethelifeyoulive.law. That's John at lovethelifeyoulive.law. So drop me a line, email me, let me know what you think, let me know if you have any questions, and if there's a question you want me to address on the air, let me know, and I'd love to bring it up and share it with the rest of the audience. Thank you for joining me on Love the Life You Live. This is John Hilton. I invite you to join me next week, Saturday at 11:30 a.m. for more of the thought leaders, the business people, the artists, the authors who will bring you more meaning and joy to your life so that you can truly love the life you live.